gentlemen, please rise. The Honorable Appellate Court of the Third Judicial District of the State of Illinois is now in session. The Honorable Liam C. Brennan presiding.
Please be seated. If we could call the case.
324-0567, the people of the state of Illinois, appellant by Laura Bylon versus Travion D. Terrell, appellee by Andrew Boyd.
All right. May proceed.
May it please the court, counsel, Laura Bylon on behalf of the people. The trial court erroneously granted defendant's motion to suppress evidence of his cell phone records. This court should reverse the trial judge's order granting defendant's motion to suppress because probable cause supported the search warrant and because the good faith exception applied even if it did not. The issue here is whether the warrant issuing judge had a substantial basis for finding that probable cause existed. Great deference is owed to the issuing judge's decision. Probable cause is a practical decision that considers the totality of the circumstances, common sense, common knowledge, reasonable inferences, and whether there is a fair probability that evidence of a crime will be found in a particular place to be searched. Here, the search warrant was supported by probable cause. The complaint and affidavit for search warrant detailed the steps connecting defendant to the suspect vehicle. First, officers obtained the video surveillance footage of the suspect vehicle. They obtained video surveillance footage from the Hooters restaurant and the Rise dispensary, the restaurant being where the victim's car and the suspect vehicle first encountered each other, and the Rise dispensary footage capturing the chase of the victim's vehicle by the suspect vehicle.
Can I ask about these photos? I mean, it seems to me that it might be fair to say that the complaint oversold the two vehicles are consistent. There's no question about that. But as you look at the photos for argument today, I mean, would you be comfortable saying they're definitely the same car?
From me as a layperson?
Sure, you as a layperson.
No, however, the officers knows how to identify the unique features of the vehicle. He knew that the fog light was only produced between 2016 and 2018, so that narrows down the model years. He knows how to track down that it's a Malibu. Plus, there's also the dark tinted windows and dark rims that don't come standard on the cars. The rims have a specific pattern. And there was more than just the photos too. There were surveillance videos. The officer stated in the complaint and affidavit that he viewed the videos. Moreover, they searched the footage for black Chevrolet sedan. As far as whether this could be the same car or many other cars out there, they searched for black Chevrolet sedan. They got hundreds of results for 4 days between Joliet, Crest Hill, and Shorewood. However, with the dark tinted windows, specific rim pattern, model year, and dirt on the side of the vehicle, only one of those black Chevrolet sedans in the area matched the suspect vehicle.
2.5 hours before going in a different direction.
Well, if this vehicle was such a common type of vehicle that it's going to be all over the place, there would have been more than one that matched. Instead, only one matched based on all those characteristics put together, which the officer knew how to attach the significance of them.
I don't know that this is in the record, and if it's not, you can just tell me it's not and move on, but can you just describe what this flock system is?
That is not on the record.
All right, continue.
So all I know about the flock system is that there's cameras in Plainfield, there's cameras in Joliet, and there's cameras in Shorewood that were searched.
So it's whatever these cameras that happen to be in places that law enforcement are using captures.
And I know that they captured, I believe it was referred to as hundreds of vehicles when they searched black Chevrolet sedan, which is the general type of the car. But I know that only this one vehicle registered to defendant was the only one that matched the picture, matched the criterion from the surveillance videos and surveillance footage. So if this had turned up dozens of cars that also matched that vehicle in the area, then yes, the officers couldn't be sufficiently wouldn't be a sufficient probability that the suspect vehicle was the vehicle depicted on the flock footage. But based upon all the facts that were, connected in the investigation by the officers, the people submit that there was a sufficient probability that it was sufficiently likely that the car depicted on the flock footage was the suspect vehicle. And that car was registered, to defendant and Tiffany Terrell. The victim stated that she saw two men in the vehicle and defendant was the male registered owner. Case law allows that an officer may reasonably presume that the owner of a car is likely the driver. Of course, it's possible someone else could be the driver, but it's sufficiently likely for probable cause, which isn't proof beyond a reasonable doubt, just a fair probability. It's sufficiently probable that, as the male registered owner with two men, being in the car, defendant was the likely driver. Plus, the victim had identified Barfield as being in the vehicle, and officers investigated the Facebook profiles for Barfield and Facebook profiles for defendant and discovered they were Facebook friends. And that a reliable confidential informant informed an officer that Barfield had been known to travel in a black Chevrolet Malibu recently, and that is a type of car that defendant had generally. So under the totality of the circumstances all put together, which is what the probable cause analysis requires, there was a sufficient probability that defendant was the driver of the suspect vehicle.
So Facebook friends.
That
I'm not a fan of Facebook, so I can't speak for myself, but people I know have thousands of friends, most of whom they don't actually know. So the name showing up as a Facebook friend, it doesn't necessarily seem particularly compelling.
on its own, but it's part of the total analysis. So once the defendant was the registered owner of the suspect vehicle and Barfield is in that vehicle, as identified by the victim, that's just another piece of corroboration suggesting a totality of the circumstances probable cause that defendant was connected to this offense. I believe people generally know people that different social medias, I feel like, result in people having parasocial relationships with strangers. I feel like Facebook is one where it's more friends with each other, but that's
He's
just-
never run for office.
I was just about to say,
But-
yes.
but I'm not-
Elected judiciary.
Neither has defendant or Barfield, as far as I'm aware. So the people submit there's a sufficient probability that defendant was the driver of the suspect vehicle.
Let me ask you this question. Let's say that you get all the information that was retrieved as a result of the search warrant on the phone, the triangulation to identify if that phone was in that car in the area. Even if it turned out he wasn't. If it turns out his phone doesn't ping in the area where the vehicle was, would you argue that if the owner of the car, it wasn't there, that it's likely or even highly likely that he would have communicated with whoever he lent his car to, whoever had possession of his car, even if he wasn't the driver?
Yes, even if he wasn't the driver, he's still possible that he's communicating with who's in the vehicle. Yes, because somehow Barfield gets in that vehicle and that vehicle is registered to defendant. So there's location data and also the fact that phones are used to communicate with others. And that's the nexus to the cell phone records to the shooting. It's common knowledge people generally take their phones with them, and even if they don't, that they're used to communicate, set up plans with other people. Additionally, about cell phones, Detective German did state in the complainant affidavit for search warrant that he had 18 years of experience, including training in forensic cell phone investigations and in call detail records. He stated that obtaining a subject's cell phone records and call detail records can assist in determining the location of the mobile device, routes of travel, and communications to other vehicles. The people also argue that the warrant was not overly broad. Here, the search warrant searched for evidence of the offense of aggravated battery with a firearm in a limited time period. The cell phone records held by T-Mobile. It wasn't a fishing expedition for other offenses. It was a specific search for evidence of the January 15th shooting, and similar scopes of actual cell phones themselves, which aren't date limited. Courts have viewed Warrants that search for any evidence or all evidence on the phone have been viewed as permissible in scope. Even if this court does not agree that probable cause existed, the exclusionary rule should not apply here. The officers acted in good faith and objectively reasonable reliance on the search warrant issued by the neutral and detached magistrate. It contained a detailed investigation narrative connecting defendant to the shooting through his vehicle and his connection to Barfield. It was far from bare bones, and so the good faith exception should apply. Are there any further questions?
I do.
You will have an opportunity to rebuttal. Thank you.
Thank you.
Good morning. My name is Andy Boyd from the State of Health Defendant's Office, and I represent Travion Terrell. If it please the court and counsel. At root, your honors, what this case is about is a fundamental right that Americans have to keep their private affairs private. The police simply cannot be given free rein to perform general exploratory rummagings through individual cell phones or cell phone records based on an increasingly dubious series of guesses or assumptions.
Sometimes that is what police work is though, right?
It is, that's correct,
Or
but
at least that's where it begins.
that's where it begins. The touchstone of the Fourth Amendment is reasonableness. And what we've got here, your honors, with respect to the state, is an increasingly unreasonable series of guesses or assumptions made by the police officer who drafted this affidavit that gets him, he believes, closer and closer to Travion. And what this officer does then is make a huge, unwarranted inferential leap. That he says that he simply believes that information about this offense might be found on Travion's cell phone records.
Would you agree with this statement? If it's probable that the two cars are the same. In other words, if the vehicle that Barfield is observed in is owned by Terrell, there's probable cause to look at Terrell's cell phone. Would you agree with that or not agree with that? You would not agree.
Absolutely not.
Why not?
The first thing I would say is that I agree with your honest skepticism about whether or not these two vehicles were actually the same. If you look at these color photos that the state very nicely introduced into the record, in the affidavit, what the affiant says is, well, there's a very distinctive salt pattern on the side of this car. And then you look at this color photo and there's nothing distinctive about it. It's just the general mush of salt that you get when people drive around in the winter. But to answer your honest question, no. Even if these cars are the same, and I will assume that for the sake of argument, but this is not a concession, this is just an assumption for the sake of argument, no. Because what we've got then is we start down the road of this officer who drafted this affidavit, making an increasingly unwarranted series of guesses or assumptions. And the first one is, well, there's a guess or there's an assumption that Travion was the one that was driving this vehicle. Yes, he was one of the registered owners of the car. One of two people were registered owners of this car, Travion and Tiffany Terrell. And it might be a logical inference that generally the owner of the vehicle was the one who was driving it. But in this particular case, the individual who was driving the victim's car wasn't the owner of that car.
Ms. Byron, in her summation, indicated that it was, I know that the victim identified Barfield as being in the car. And then she indicated that it was also indicated that another person in the car was a male. That wasn't my recollection, but do you agree with her as it relates to that?
That's correct. Another male was identified.
So that was the case.
Yes.
So we have two males in the car, which wouldn't that suggest further that it might not be Mrs. Terrell?
It certainly suggests that it's whoever Tiffany Terrell was. It suggests that it's not her, but it doesn't necessarily suggest that it was Travion, because again, it's just a guess. It's just an assumption. And again, to repeat, in this case, it's a bad assumption because the victim was not driving the car. The victim was driving the mom's car. So in this particular case, the case right in front of us right here, right now, that assumption has been rebutted in the case of the victim.
So you don't think that even if it turned out they got their search warrant, they get all the records off the phone, and it turns out his phone argument is he wasn't the driver. You believe that it is not at least probable that the owner of a vehicle knows who's in possession of his car? And communicated with them on the phone, that's how everyone communicates.
Again, Your Honor, with respect, that's just another assumption, that's just another guess. So Your Honor's proposition is just another one of these assumptions or guesses that we pile on this whole list of assumptions or guesses that doesn't even get us anywhere near. And this is the main problem in this case, from my point of view, is that none of this investigation, these numerous pages in this affidavit about this investigation, none of that stuff formed a concrete nexus to Trayvion's cell phone or his cell phone records. You've got this long investigation into the car. Counsel spent a pretty good chunk of her argument arguing about these cars, whether or not these cars were the same. Who cares? It doesn't matter. If the cars weren't the same, well, then certainly we should win this case. But it doesn't matter. Even if these cars were the same, we start piling assumption on top of assumption and guess on top of guess. And the problem is there's no concrete link to the cell phone records. And the law is crystal clear that there's got to be such a concrete link. There has to be a concrete factual link to the cell phone, and there's just not one here. And that is the essential probable cause. And look, the state's argument here, again, with respect to counsel, is absolutely breathtaking in its scope.
Counsel, what about the
Everybody-
good faith exception?
Please.
What about the good faith exception? I mean, you have to establish that the affidavit was so lacking in indicia of probable cause as to render official belief in the existence of probable cause entirely unreasonable. That's what
Correct.
some of the cases said.
Correct. And
And we have to give deference to the trial judge who signed the warrant, to his determination. So how do you address that?
deference doesn't mean rubber stamp. This honorable court had, with all respect, has an obligation to look very carefully into whether the magistrate judge's decision was the correct one.
But is it
Yeah.
still lacking in indicia of probable cause?
This, as I've explained in my brief, and I'm trying to explain here, this was a bare bones warrant that was based simply on the belief, and it even says that if you read the affidavit and you read where this officer makes this inferential leap to the cell phone records, he uses that exact words. He just says, I believe that Trayvion's cell phone records are going to contain evidence of this crime. And that's after 10 or 11 pages detailing this investigation into whether these cars are the same, into how they got this guy's Facebook accounts, how they got these guys' phone number, how they got his license plate. And then he simply makes this jump, this huge inferential jump, and he says, I therefore believe that there's evidence related to this crime is going to be found.
Back to Justice Peterson's point. I mean, if it's the same car,
Right.
then you have Barfield in Terrell's car. You have you have another man at least unknown in the car, but it's Terrell's car. And they are Facebook friends, whatever that weight you want to give that. And you have this independent person saying that Barfield's been, tooling around in a Malibu lately. Why would it be unreasonable to suspect that there would be conversations, texts, things related to Barfield and why Barfield's in Terrell's car, if it is Terrell's car and Barfield's in it? Why would that be so unreasonable?
With respect, Your Honor, you're making the same inferential leap at the.
I'm asking why the leap is unreasonable.
Because it relies on this general idea, and we're just pulling this from outside the record. I don't even know where this comes from. But this general idea that the state says, well, everybody knows that everybody has cell phones. Everybody knows that everybody takes these cell phones everywhere.
Well, we
Everybody
do
knows.
know though that Terrell has a cell phone and we know that Barfield has a cell phone. Because those are the two records we're requesting.
Well, we know that because this warrant was executed. They didn't-
No, we know, what were the two phone numbers that the warrant was seeking to be searched?
You're right, excuse me.
Right, so we do know they had cell phone.
We did know they had cell phones. But look, Everybody doesn't take their cell phone everywhere. That's just not true. If what we're gonna do here is go outside the record, then okay, let's do that. I don't take my cell phone everywhere.
This case isn't about absolutes, it's about what's reasonable.
Sure, sure. And what the state's asking is absolutely unreasonable. The Fourth Amendment simply cannot be stretched as far as the state wants to stretch it. And with respect, if this court realized what the state is asking, everybody's privacy is.
So I want to go back to Justice Anderson's question about the Leon good faith exception. I don't think deference to the magistrate is relevant to the Leon good faith question. But what is relevant is we do have an officer who, maybe the officer got it wrong. And maybe you're right. And, you know, the fact that it's probably the same car, that Barfield's in it, that they're Facebook friends, maybe altogether that's just not quite enough to issue the warrant. But is it so deficient that we think essentially this officer was trying to do a subterfuge on the court? And I mean, it's doesn't, we want officers to get search warrants, and that's the point of the Leon good faith exception, right? Unless what they're doing is so obviously deficient, we're gonna ultimately not employ the exclusionary rule if they went through the effort to get a warrant. How is that the correct ruling by the trial court?
I refer your honor to this Manzo case that I've cited in my brief. And there's a quote here that I think answers your honor's question. A bare bones affidavit states only suspicions, beliefs, or conclusions without providing some underlying factual circumstances regarding veracity, reliability, and basis of knowledge. A bare bones affidavit is conclusory, one that asserts the affiant's belief that probable cause existed. That's what this affidavit is here. It's conclusory. It simply states the officer's belief. There is a huge inferential leap that this officer took between the investigation into these automobiles, between the investigation into the Facebook accounts, and finally coming up with these phone numbers to, okay, I'm going to assume, I have a suspicion, I'm going to make a conclusion that there's evidence related to this offense found in Mr. Durrell's cell phone records. And that's why this is bare bones. To answer your honor's question, it goes right down the list of the factors that the Manzo court used to determine whether or not an affidavit was bare bones. Suspicions, beliefs, conclusions, without providing underlying factual circumstances. That's what happened here. That's exactly what happened here, and that's why there's no good basis for this warrant. That's precisely the problem. And if your honors aren't convinced that this was a bare bones warrant, well, then it certainly was overbroad. It certainly was overbroad. Now I will, now is my unfortunate
So
error.
it said either nothing or it said way too much. Sounds, you're saying it was either bare bones or it was overbroad. That seems like you're saying it was either nothing or it was a lot.
Well, if only one of those is needed to find that the good faith basis wasn't satisfied. It was bare bones, the good faith basis wasn't satisfied. It was overbroad, the good faith basis wasn't satisfied. In my personal opinion, it's both.
If it's the overbreadth issue, does the whole warrant fail or just the overbroad nature of certain requests fail?
The whole warrant fails because the whole warrant is based on this series of assumptions.
But overbreadth has to do with what's being sought. Is that not so?
Overbreadth has to do with what's being sought. That's absolutely correct.
So, I mean, if some of what's being sought is permissible and some is overbroad, beyond the pale, outside the scope of what they should be asking, why should the whole warrant be quashed?
First of all, because it's bare bones.
But I'm just focusing on overbreadth as an alternative basis to not employ the good faith exception.
Because this warrant authorized a search into virtually the entirety of these cell phone records. And the same assumptions are required in order to get anywhere in this warrant. In order to get into these cell phone records at all, any sort of these cell phone records, location records, text records, whatever these records might be, in order to get anywhere, you have to make these same assumptions You have to make these same unwarranted inferential leaps. You have to make these same guesses. You have to make these same conclusory statements. That's why the entire warrant fails, not just part of it, the entire warrant.
I don't have any other questions.
So thank you, your honors. We would ask that this court, affirm the circuit court's judgment and thank this court very much for its time and consideration in this case.
Thank you, sir.
Rebuttal.
The people will address a few points from defendant's argument. First, concerning the privacy concerns. The privacy is protected by the requirement that officers get a warrant. In this case, officers got a warrant. And the exclusionary rule is not meant as a remedy for an invasion of privacy. Instead, its purpose is to deter future Fourth Amendment violations. And here, where officers relied in good faith on the search warrant issued by the judge, that the good faith exception should apply. Concerning the salt on the vehicle, the warrant, the complaint and affidavit warrant stated that it was dirty with snow and salt on the passenger side of the vehicle, which is similar to the video surveillance of the offending vehicle. On its own, two dirty cars, no, not a match, but probable cause is the totality of the circumstances. If there had been a squeaky clean car 2 hours before, and then the suspect vehicle is super dirty, that's gonna rule it out. But here, it's just consistent amongst the other features that match.
I have a question about that. So in the affidavit, the officer, I'm gonna summarize, basically says, I think the pattern of dirt and salt, because it was winter, looks the same, like it's the same. And the two best photographs that we have in the record, I can't see that. So here's my question. If what was attached and what's in the record that we get to look on the corroboration issue doesn't quite fit what the officer has said, are we allowed to still take the officer's word for it? What picture was he looking at if we couldn't see it in the ones that were attached?
Well, the officer also had the video surveillance footage, which would show the cars in motion, and he didn't say, this is an exact match, someone wrote on the side, this is Barfield in the car with me, defendant. No, that's what he said, is on page 13 of the complaint for search warrant, which he just said that the vehicle appeared to be dirty with snow and salt on the passenger side of the vehicle on the flock safety images, which is similar to the video surveillance of the offending vehicle. So he didn't say it's an exact match. He didn't oversell it in the complaint and affidavit for search warrant. And the relevance there, as I suggested, was if this car is clean, or there's no dirt or much less dirt on the side of that vehicle, then it could be eliminated as a match. But instead, the officers stated that it was consistent with it. And again, that's just one of the totality of the circumstances. We have the 2016 to 2018 model year, and then the customization in the dark rims with the rim pattern and the dark tinted windows that not most off the lot Chevrolet Malibus aren't going to have. Additionally, defendant has asserted that there's just assumptions and guesses. The people respond that it's instead a consideration of the totality of the circumstances with common knowledge and reasonable inferences. And the good faith exception boils down to whether officers could believe in good faith that these two vehicles were sufficiently linked. Well, that's why officers sought the warrant. They presented the information they had about each vehicle to the warrant issuing judge, and for the warrant issuing judge to determine whether there was probable cause. The warrant issuing judge said yes. Having obtained that search warrant, the officers could reasonably rely on it in good faith, so the good faith exception should apply. Well, the people would ask that this court reverse the trial judge's order granting defendant's motion to suppress. Thank you, your honors.
Well, we thank both sides for a spirited argument. It is an interesting case. We'll take the matter under advisement and render a decision in due course. Court is adjourned until the next argument. Thank you.
Thank you both.
Recess as stated. This court is now in session.
Morning, folks. Please be seated.
Three 24-0346 and remarriage of James Nadolski, appellant by Robert Black and Teresa Nadolski. Appellee by Timothy Reed.
Mr. Black, you may proceed.
Thank you, Your Honor, and good morning. May it please the court and counsel. My name is Robert G. Black, and I represent the appellant James Nadolski here. This case is all about this thing called a true up. Now,
What is a true up?
and that's the main thing that I want to get at. True up, you don't find it in the Illinois Marriage and Dissolution of Marriage Act. It's not a legal term of art. It is a form of reconciliation.
Where did it come from?
I guess just usage over time where one or both of the spouses has a fluctuating income, a non-guaranteed income. So the true up is in place so that you set the base amount of what the maintenance is or should be based upon present earnings. And you come back and say, okay, here's where the financial records for the year. And based upon those financial records, maybe you true it up, maybe you true it down.
How about just calling it an adjustment?
I would love to call it an adjustment, Your Honor, but that's kind of one of the ways the phraseology has developed. But one thing about this, in doing this reconciliation, one thing you have to remember that's important, so there has to be a base rate to begin with. So when we had this judgment at MSA, marital settlement agreement, back in 2016, no base rate for maintenance is set. Maintenance is reserved. So there is nothing at that point to true up. This provision doesn't come into effect. It doesn't really have any effect.
And wasn't the base rate just zero?
Zero basically.
I mean,
But I
can
can-
that zero be a base rate?
I don't know that a zero can be a base rate. I mean, 0 times something is still zero, I guess.
How do you define base rate? It seems like we've got this unique little argot
Right.
to this area of law, which was created by attorneys.
Well, I can define the base rate here, basically, 2 years later. Mr. Dawson comes in on a petition, a change, alleging a substantial change in circumstances. He now has, instead of being self-employed like he was at the time of the entry of the judgment of dissolution, he now has a salaried job and it's a set salary. So he can come in and say, okay, this is what my salary is, and based upon that, and based upon Mrs. Dawson's earnings, we can set what maintenance will be, and it was set at that time at $1,900 and change. That particular agreed order did not contain the same kind of prove-up limitation. And really, it shouldn't have, because now we're dealing with set salaries as opposed to fluctuating income. The whole purpose behind the prove-up and doing the reconciliation is somebody has, you own your own business, gross profits may be great one year, maybe lousy the next year. And that's when you come back in and say, okay, we're gonna readjust as need be. But where there is an actual salary, there is no need for that sort of reconciliation. There's no need for that aspect of things.
Well, if you have a salary and maintenance is reserved and there's no order for a dollar amount of maintenance, but it's reserved and you're a W-2 employee.
Yes.
I don't understand your argument.
Well, the difference here
Let's
is,
try and figure out.
sure, difference here, Your Honor, is at the time that he was self-employed, at the time of the MSA, they guesstimated $90,000 in gross income. Come the 2 years later, when he has the job, he has a salary, and they have salaries of $162,000. So you're weighing $162,000 as against the other earnings versus the $90,000, which is fluctuating anyway, versus the other earnings. And that's how you can come to what is a set amount of $1,900 based on the statute. So that then it becomes the term, the maintenance. And there again, this second order, this agreed order, does not contain any language that would equivalent to this proof of thing. The other distinguishing feature about a proof as it's developed is that the true-up provision itself recognizes the change in income because, well, let me strike this. The true provision itself takes into effect or account and subsumes that there is going to be a substantial change in circumstances because of the vacillating incomes. So here, when we came back in 2018, a substantial change of circumstances was alleged. There isn't or wouldn't be a substantial change of circumstances if back then we had, or wouldn't be a need to do the substantial change of circumstances if back then we had the working true-up provision with some sort of base amount salary. So the fact that there is
What does substantial change of circumstances go to? I mean, am I correct? The MSA said, in effect, it did award maintenance, didn't it?
it reserved maintenance, there was no award of maintenance,
Okay, so no formal award of
no
maintenance.
formal award.
But it required him to pay maintenance if his income went up, did it not?
And I think that's kind of the rub, that's kind of the interesting thing here, Your Honor, is that, it's set at zero based upon these levels. And how do you true up or prove up from no base amount?
I apologize, Justice.
Oh, no, that's fine, and. Yeah, because you define, sure, but isn't it basically a review? An adjustment is a true up?
It is, however, we have this order, agreed order, from 2018 that says, okay, your income now is this, it's set, you know it, your salary is this, your employed is supposed to self-employed. So based upon that income,
Well, self-employed is still employed.
well, yeah, but self-employed.
He's a salary worker as opposed to a business owner taking
Right,
a profit.
so, self-employed is not salary, I mean, it's just,
Well,
so. Now you have a salary in place, a definitive job. And that salary can be articulated, they know it, they match the levels. Here is what the parties agreed upon as the maintenance, monthly maintenance from this point forward. And there is no like provision for a true up here because there doesn't need to be one because we don't have the widely fluctuating potential incomes. Does that answer the question, Nathan? And I look at so from that point forward, any modification would have to be by statute based upon a substantial change in circumstances. Now, I look at this Article 3 of the MSA way back when, and it's a little difficult to follow. I think one of the things that you see right away is the numbering system. The numbering system has, at one point, you got a 1 with an underline, a 2 with an underline, then you've got a 3 with no underline and no indent, and then you've got another 3 with a period and an indent. It's just very confusing, but the thing of it is that it talks about a base rate and there's no base rate, and it talks about a change in circumstances in what is numbered paragraph 3 without anything after it. That it shall continue until such time as there is a change in circumstances. And there's a problem, there's a rub again, that when you do have that set up for a true up, you're already presuming a change in circumstances. So then why would this say change in circumstances? That doesn't coalesce, it doesn't make any sense. Now, again, when James filed his petition for modification in August of 2018, he specifically alleged a substantial change in circumstances, which we have discussed, which is now his salary, which is more than what was projected in his earnings 2 years prior to that. When the trial court sent its order, then the agreed order, it said that amount per month, which is equal to the guideline maintenance based on 162,700 of income for James. And 69,852 for Teresa. Now, as an aside, this has been ongoing for some time. So we have the judgment in the MSA 2016. We have the petition filed in November, in 2018. We have the read order, November 2018. We don't have anything by Teresa filed until 2023. It begs the question, why the delay? I mean, if she was so certain that there had been a reason to come back in because of an adjustment of income was needed, it's a long time to sit on your hands. That would be my observation. Well, and two, next recognized feature of doing a prove-up is financial records. I think the record here is charitably, I'll call it bereft of real information about financial records and financial information. I think what happened here is that there was an exhibit to one of the trial briefs that said, here's what I believe it should be. And then the court adopted it without any discussion, without any viewing, without its own calculations. And there's a problem there. And relatedly, the court at one point ruled that Mr. Podolsky had no credibility because he didn't recognize the term true-up. That meant he must be not truthful because he didn't recognize the term true-up, even though they had been emailing back and forth about whether there should be differences. Well, this is just a dispute between them. I don't know how many people know what the term true-up is. I didn't know this case, and I suspect that most people in the public would not know it either. So for the fact for the trial court to say, I'm disregarding all of your testimony because you said you didn't know what true-up, you said you heard the term, first heard the term true-up in January, but you have these emails before then. I think that's just an abuse of discretion. And that lends itself to the fact that the court said, okay, here's the figures that she provided me. I'm not going to believe him or listen to anything that he has to say. And these are the figures I'm going to accept. I think that's wrong. I think that's an abuse of discretion, presuming that we still have a situation where that needs to be considered. Underlying this is a contempt finding and purge order. It was a reasonable belief, we believe, shown by the record, that the monthly maintenance was $1,900. And it was paid that way. All the way through. This increase, it's an honest belief. I don't think that even if we presume that there was some sort of change intended, and we don't believe there was by way of the record and the documents, but even if you presume that, it's an honest belief.
What about the failure to notify Teresa of the income increases in a timely manner? And doesn't that go to his good faith?
Well, it would certainly if it was under a petition for change based upon a substantial change in circumstances, that would be part of the allegations and that would be part of the proofs. But that's not what we have here. That didn't happen here.
I mean, how do you square that with him sending a number of $1,818, in other words, doing his own recalculation, with him not thinking a recalculation was important?
That was, if I'm correct about the record, that was a 1 month thing, and that was corrected subsequently.
So I mean, but he recalculated.
He did.
And never once did he say, I'm not required to reconcile.
As part of the basic back and forth here, the record shows that there was a recalculation. There was apparently some sort of a combination that was attempted to be reached, and when based upon his calculations, this is what it showed. But the record also reflects that what was ordered by the agreed order of November 2018 was routinely paid. Might have been a couple dollars off, might have been a couple days late, but it was paid. It was all paid up. Well, by all of this, I think I get the high points. We would ask that the orders of January 16 and 2024, April 30, 2024, be vacated or reversed, that there be a finding of no arrearages, and that there vacate the contempt finding and the purgement. And I'll save the rest for
I do, if you don't mind.
unless there's questions.
I do. You have indicated there's no need for a reconciliation when salaries are not expected to fluctuate in a significant manner, but I mean, isn't it a practical matter that some people agree to reconciliation just to avoid coming back to court?
Absolutely. Well, most definitely they do, and that's their choice. The agreed order here says nothing about any sort of reconciliation or coming back into reconcile. All it says is, here's what it is and here's the amounts. And, you know, if there's a substantial change in circumstances, come on back in.
And can you tell me what in the agreed order with any specificity negated or abrogated the true up? Or are we left with what you're claiming is an inconsistency between true reconciliation language and 510 language?
I
And then
think it's more than an inconsistency, for the basic reason that I articulated, that to begin with, there's no base amount. The reconciliation presumes the base amount, and there's no base amount. It's reserved. There's nothing to reconcile. There's nothing to come back and take a look at. When we come back 2 years later, we have the agreed order, there is an amount, but there's no similar language about reconciliation. And the reason again for that is fluctuating income in Mr. Nadolski versus a salary, an identified salary.
thank you, sir.
Thank you.
I have an opportunity in rebuttal, Mr. Black. Mr. Reed.
Justice? Justices, may it please the court, no worries, Timothy Reed on behalf of Teresa Nadolski, she's the appellee. Justice Holdridge, she started toward the beginning of this asking along the lines of,
Could you speak up just a little
where
bit?
does the true up come from? The true up comes from the contract that the parties entered into, and that contract still remains in place today.
But it's never defined in the contract, was it?
Well, the phrase true up, agreed. It's I think in lieu of copying, pasting the language of the marital settlement agreement over and over again throughout the litigation, what everyone has done is say, we're gonna call this a true up. But the concept is in the contract that the parties entered into, and that contract makes very clear that anytime there's a change in the base in the incomes of the parties, they're going to immediately calculate, and that amount is going to be used to Mrs. Nadolski.
So that now you define true up in the contract.
That would be what we're talking about when we use the phrase true up. Right, we're talking about what the parties contracted to, and whatever we call it, the concept is the same. The concept is whenever there's a change in the income, there needs to be a recalculation in maintenance, and that's what's articulated.
Isn't that much more clearly understood in this little term? That's what it means, isn't it?
Fair enough, right,
Okay.
right. And so within that contract, every time there's a change in income, it needs to be recalculated. But Article 3 of the marital settlement agreement specifically says, after there's a change, the parties immediately agree to immediately make additional adjustments after any base rate payment. So that article is already contemplating not only what happens when maintenance starts being paid, but it's contemplating what happens after that.
What's the MSA contemplating when the original figure is 0?
Well, it's.
And what has to happen
What's it-
for it to go from reserved to a dollar amount that's required to be paid? What has to happen?
So what it says is if either party has an increase in income of the base rates, and it says in parentheses what those were, 96,000 and 65,000. The party with the increase must immediately notify other, and then it shows you how to calculate it.
60/40.
Right, it's the next paragraph talks about the various, which was the maintenance statute at that time.
Okay.
And so that would be the answer to it. What the agreed order that was subsequently entered does, and I do think that the phrase at the beginning of that order is very telling. It says pursuant to Article 3. And at least my reading of that phrase means that what we're doing is we're trying to accomplish what's set forth in that, right? And what they're doing is calculating the amount that's owed on a monthly basis based off of the changes in the income. It's memorializing that, but nowhere in that agreement does it do anything to talk about we're getting rid of the way we're going to calculate it, or that we're going to constantly recalculate it. It doesn't get rid of those provisions. It just applies those provisions. And that continues until this date. Another thing that came up today, and I think came up in Mr. Nadolski's reply brief, is this concept that the marital settlement agreement was somehow the way it was because Mr. Nadolski was self-employed. It doesn't say that anywhere. What it does is it says he is self-employed, and it says what my client does for a living.
Well, wait, would you kind of like speak up a little more, get closer to the mic?
Sure.
Yeah.
What it does is it
Yeah.
says, it's set this room, I knew it was gonna be a problem. The, what the document says is that whenever there's a increase in the income, the base rates, and it articulates what those are, that's when we're going to change the maintenance amount. It's got nothing to do with what they're doing for a living. Just by way of example, if Mr. Nadolski was self-employed today, he still has to adjust his maintenance amount based on his income. This is about income, not whether it comes from self-employment or not. That's reading outside of the language of the contract. And I don't think anywhere is either party suggesting that this is an ambiguous provision in the MSA. The only thing that I'm hearing and reading in the briefs is that somehow the agreed order that was subsequently entered just completely negated all of the language in Article 3. And that's what they say. Actually, in their brief, they say that it replaced Article 3. And that on its face would lead to absurd conclusions, because Article 3 just doesn't talk about the amount of maintenance. It talks about the duration of maintenance and the like, and it talks about how maintenance is going to be terminated. In no way could it be said that we're getting rid of those provisions. And it's the same concept. The same concept is in no way, just like it doesn't address, just like the agreed order doesn't address the duration of maintenance, it doesn't address what the parties contemplated and how they're going to continuously recalculate maintenance. It doesn't do that. And so Mr. Nadolski did not pay the amount that was due. Okay, and so we've got a petition for rule to show cause damage. On its face, the failure to pay maintenance is contemptuous. Nowhere in the record does Mr. Nadolski assert that he wasn't able to pay. He says he didn't know about it. Well, we're violating the court order. That's A, not a sufficient excuse. But B, even if it were a sufficient excuse, the record is filled with, as was mentioned earlier, there's emails back and forth where Mr. Nadolski is acknowledging that he had a requirement. He mentions the 40% requirement. He knows it's there. And this concept that his lack of credibility was specifically related to this phrase true up, there's a lot in the record to show why his credibility was lacking. The emails going back and forth that he knew he needed to increase the amount or decrease the amount when it suited him. That's in the record. The other thing that's in the record is that he was not forthcoming with his income. right? In fact, the emails that were being exchanged, that was during a period of time where he thought that he could get a reduction in maintenance. Because the amount that he was proposing was going lower than the amount that was agreed to. So those various things go with his credibility, in addition to this concept that he's saying that he's never heard the phrase true up. So he violates the order.
Well, we have to have a clear order, first of all, for someone to violate it and be held in contempt, correct?
100%. And, and that's what my statement is, my reading of the language in the documents, right? The two words that we're really talking about is that it is clear. And not only is it clear, but the evidence shows that he did know what to do, right? Because he's referring back in the emails to the paragraph that talks about how to calculate maintenance on an annual basis. And so for that reason, I think it is a clear order. There's nothing in the second order that at all attempts to articulate a amendment of that, right, of that language. And it's one of those situations where, and I've done this in my practice, if you are trying to get rid of a previously entered provision, it is very easy to get rid of it. You say, this provision is no longer applicable, right? You can write that language in. And in the when you've got a right that was articulated in a prior order, that is easily gotten rid of by way of writing in the words, this is no longer applicable, and you don't do it, I think that's telling. And in my brief, I cite case law in support of that concept.
So you're saying the language is clear and unambiguous in the MSA and in the 2018?
Yes, Judge. And so I'm saying, and so moving forward, these provisions, as are placed in the MSA, they still are enforced. And that's moving forward, because the second order did nothing to change that.
If I could ask, the second order says, which sums, the payment of which covenant is herein above made shall be subject to modification with respect to the amount payable pursuant to section 510. In what circumstance would 510 come into play if all we're talking about is a true up or reconciliation? When would a court need to consider the 510 factors, and by inclusion in 510 the 504 factor?
Right. Well, again, as a starting point, obviously there's a lot of case law out there about what constitutes a substantial change in circumstances under.
So what's 510 say?
510, paraphrasing, because I don't have it in front of me.
Well, that would be,
But paraphrasing is there can be a modification if there's a substantial change in circumstances. Then the case law will talk about with true up situations in particular, to talk about circumstances where there would not be under 510 a change in circumstances, given the fact that the parties had already contemplated that change in circumstances. I think the commonly cases that talks about.
your argument is they did contemplate a change of circumstances by the mechanism to adjust movement.
Right, that would be my argument. Now.
So why would it ever get into court?
To get back to your question, that is, it's a limited, I would imagine, number of circumstances, right? If everything had changed today, except the parties' incomes were a little different, and someone came in today and said there's been a substantial change, we need to get rid of all this. My argument would be, no, you can't do that. That was contemplated.
Okay.
But there's a wide variety.
Or if someone became disabled or something like that.
All of those different things, because there's certain termination provisions that are quoted here that may not be covered, right? That someone could still come in under 510. I think you, Justice, you gave it a perfect example of somebody who's disabled or the like, right? So that to the answer is where 510 comes in. I don't know that.
Well, doesn't it come in to say, before we do this true up, when you start referencing 510, there has to be the first hurdle of significant change in circumstances established?
No,
Okay,
I do not believe so, no.
why not?
if I'm understanding your question correctly, because the existing language already provides for it all to be triggered. So what
The existing language
in Article 3. Or the marital
in
settlement.
the MSA.
Right, and so the substantial change comes in, there's nothing in the marital settlement agreement that waives.
So you're saying 510
So-
doesn't really apply here, because all we have is an adjustment
Right,
of a maintenance obligation
right,
from the 2018 amount set. Is that correct?
correct,
Okay,
and,
So,
and
there's
so,
510 wouldn't even apply then, because.
not in this case.
Yeah.
I think what council was arguing is that somehow was the agreed orders way of eliminating the true up language. And my counter to that is that if you wanted to eliminate the true up, pardon me for using the phrase, but I think we know what I'm talking about. If you wanted to eliminate the true up language, there's an easy way of doing that than saying seven, then kind of ambiguously saying, well, now 510 applies, right? If that's what they were thinking, then they could have said it, and they didn't. And so I don't think it makes any change in how you apply the marital settlement.
What isn't it almost like a rule that 510 applies before you go and get the maintenance?
It would be, and that I was getting to that point is at the time that the MSA was entered, 510 applied. Right? There's no statement in here that says that it's not modifiable maintenance, right? That you can't change this order. So to my position is it didn't happen. Again, this is speculation. That order was entered just before the maintenance law was about to change. And there was a lot of language subsequent to the 510 language in the agreed order that made clear that the tax consequences associated with this new order are the same as they were previously, right? Because we're still using gross. The reason why they're using gross income on this is because it's deductible to Mr. Nadolski and it's includable as income to my client. If that would have been entered 5 months later, then at that point in time, it would have been questionable. It's been resolved what the answers are now, but it would have been questionable how that would happen at the time.
So resolved with the, well, I couldn't understand you.
It's the issue of what we're gonna do in that circumstance is now is resolved in sort of, when we modify maintenance today with an existing order, an order that existed prior to the change. We know how we're gonna deal with that now, but at the time, that would be my guess as to why all that extra language is in there. I believe I'm out of time. But if you have any more questions, I'd be happy to do that.
I don't think you so.
Thank you, Mr. Reed.
All right. thank
Mr.
you.
Black, rebuttal.
Thank you, your honors. The basic rule of contract construction is you look at the intent of the parties at the time they entered into the agreement. So that's what we have to focus on. It is undisputed that an MSA is a contract. It is undisputed that agreed order is a contract. So we look at the intent at the time these two things were entered. In 2016, there was a disparity in what might be the fluctuating levels of the incomes. Hence, there is a provision for the so-called CUBA, but it's based upon base amount that doesn't exist because maintenance is preserved. We come along then 2 years later, now we're looking at the intent of the parties at this time. And at this time, they say, he's got the salary, we can figure this out, it's $1,900 a month, and the agreed order is subject to modification pursuant to section 10 of the act. So while it didn't say there is no longer a prove-up, and prove-up was not even utilized in the first one, the effect is, first of all, it didn't exist because how do you jump up from a base amount at zero? And secondly, it's set in place here. That was the party's agreement and intent at the time of the contracting of the agreed order. The MSA was not entered because Mr. Nadolski was self-employed. The levels itself and in the review of maintenance was entered because he was self-employed. There's a big difference here. The order says he was supposed to pay $1,900 and he did pay the $1,900. There is no contempt. He made the payments that the last order of the court called for. $1,981. Just give me one moment.
Sure.
And again, we come back to the fact that by saying that there is a provision for change of circumstances in the reorder, you're basically saying there is no proof, because the proof of takes that into account and that doesn't factor in. Unless there's any other questions, Your Honors?
I don't.
Thank you.
Again, we can, and I will.
The court thanks both sides for spirited arguments, so we will take the matter under advisement and render a decision in due course. The court is adjourned until the next argument.
So we're gonna conference and. Here and speak at the 10 cents.